Right. Good morning, everyone. It's my pleasure to welcome you all on behalf of Fichte & Co. and LexisNexis to Arbitration in the Metaverse. A great way to kick off Dubai Arbitration Week. Thank you for joining us. If you need any notepads, they're over there on the left, I'm told to tell you. But with that, let's make a start. I'd like to introduce you to our stellar panel. So the first thing to say, we have Mr. Elias Ahonen, blockchain author, journalist, and blockchain legal expert. He is described as one of the first Bitcoin historians. Imagine, we're now the history of Bitcoin. It's been around, I guess 2016 is now an eternity these days. His 2016 book was called Physical Bitcoins and Cryptocurrencies. His 2021 book, Blockland, serves as an industry textbook. A frequent contributor to Cointelegraph, his expertise acknowledged in international media, including the Wall Street Journal. He holds an MA in International Comparative Law from Finland, and his thesis, Encoded Territory, explores legal questions related to NFTs and the blockchain metaverse. He founded consulting company TokenVan in 2017 and is a director of Roku, an exchange with 1.4 million users. So probably a good question to ask, what is the metaverse? So we can get a good answer there. Then we've also got Mr. Corin van Riel, head of strategy at Skynet NFT, and marketing and strategy director at Sky in Dubai. A crypto investor since 2017, starting collecting NFTs in 2021, holds the Masters in Strategic Management and a Bachelor in Business Studies. Former advisor at KPGM Strategy Group, gained extensive cross-cultural experience living in Hong Kong, Shanghai, and in Dubai since 2014, working with many leading brands in the media region across various industries. So a good person to talk to, and I'll certainly be asking about my Coinbase. I feel I can't afford a yacht yet, maybe a rubber duck, but I'm still holding out hope that this can come through. And last but not least, Dr. Laura Voda of Counsel, Head of Corporate and Commercial at Fichte & Co. Dr. Laura is leading the corporate and commercial practice at Fichte & Co., advising clients on blockchain-related areas of business. She has over 18 years experience in cross-border environments, out of which 11 in Dubai and the GCC. She is passionate about technology. Her PhD thesis was on outer space law. She's a crypto investor and currently advises clients in Dubai on NFT structuring, corporate setups, setting up crypto exchanges, processing transactions, and is a book author and lecturer as well. One of the LexisNexis key authors. So absolute pleasure to have her on board. So please give a round of applause for my panel. So there is a lot to talk about. So we'll spend the first time covering a few key topics, then you'll all have a chance to put your questions forward. So please, we want to make it interactive, so please jump in. This is an evolving area, we have different perspectives, so plenty to talk about. So with that, I want to ask an obvious question. Let's get the terminology right. Is there a settled definition on what the metaverse is? I mean, obviously we know that in the gaming space, whether it's Epic Games, Unity, Nvidia, whether we're talking about Roblox, Sandbox, we're talking about Meta, of course. Meta, some bad news today, mass redundancies, not inspiring, but it's part of the roller coaster ride that is Web 3.0. But what do we mean? Do we have a settled definition of the metaverse, firstly?
No.
Oh! There you go. You go back there, yeah.
Good morning.
No, we don't. And I can expand on that. Facebook obviously has invested heavily into the metaverse play. If we look at the term metaverse, it comes from a science fiction novel in the late 80s or early 90s called Snow Crash, where people plug into this video game and they kind of drop out of daily life and they play this video game all the time where they all interact in this virtual world and build a city in this virtual world and they live there. We can make the argument that that the metaverse already exists. Twitter is a metaverse, Facebook is a metaverse. It's a place where we come together and share information. A lot of people talk about it as a place with VR, kind of a new dimension of the internet. I personally talk about something called the blockchain metaverse, and that is a metaverse that is built on the blockchain, meaning that it is not within the direct control of anything that goes on in the world per se, but it kind of has its own essence of structure, if that makes sense.
Would you add anything to that, Dr. Laura?
Yes, of course. I'm good morning, everybody. Thank you for coming, first of all. I'm the legal voice of this panel. So obviously, from our point of view, Metaverse is a space to explore. is a concept and a non-concept in the sense that there's a new regulatory model that we would need to either invent, either export into the metaverse. It is not the first time that the humankind was in the position of implementing new legal regimes. And I would, let's say, refer to the initial regime of the law of the sea. I would refer to the outer space law. I would refer to hybrid realities that converge in the technology and legal spectrum, and the metaverse is one of them. When we discuss about metaverse, I would ask myself, what is the business model of the metaverse? What is governance in the metaverse? Because as Elias was rightly speaking, there is a metaverse on the blockchain, but at the same time, when we discuss about meta, sandbox, Decentraland, etc., these are platforms that hold metaverse applications or that give the right to specific users to own, develop, explore, trade, transact, etc. So at that point, we cannot discuss about a purely decentralized domain. So at this point, I would wonder, and this is probably one of the topics of the discussion today, what is the business model of the metaverse and where does the regulation come from? Because when we look into the previous regimes that the humankind has implemented and on all the meta laws that currently exist, for example, in the data regime or in the outer space regime, yeah, when we discuss about the metaverse, you'd see that most of the rules applying to NFTs, to coding, to smart contracts, as they are today, come from the private sphere. So very few of them have a governmental backup. There are a few elements of regulations that have been enacted recently that we're obviously going to discuss about. But in the end, the metaverse is a regime to be developed. Yeah? Some people discuss about the dystopian projection of, let's say, the human sphere and of our existence in the 3D projected into the metaverse, but this is not all. So probably one of the topics of our discussion today is how do we implement this regime into smart contracts, and in particular in relation to arbitration, which is actually the main, let's say, event that we are here today to talk about.
So I think let's go a little further on the terminology here. So let's just to define, when we're talking about NFTs, for example, there's a lot of hype out there, a lot of interesting artwork, of course. In the gaming world, certainly a key area as well. So can we just define, what do we mean by a non-fungible token, NFT? What do we mean by it, and where are we now with all the latest developments we're seeing?
Yes, good morning everyone. First off, thank you all for coming, like Laura mentioned. Yeah, non-fungible token, I think the easiest way to understand that if you translate the word fungible, which means interchangeable. It's a word used in the financial industry, which means if I have a $100 bill, it doesn't matter which $100 bill you possess, it all has the same value. So if I would borrow a bill from Laura, I can give back the same bill, which means fungible. It's exactly the same, it's identical, so therefore it's interchangeable. I can exchange it with everyone. Non-fungible obviously means the opposite. Like your passport is non-fungible. If I give my passport to someone, I want my passport back, otherwise I can't travel. So it's, I think, one of the best examples, being unique. It has value only to me, not to other people. For other people, just a piece of paper, and they may be interested in my travel history. But besides that, you cannot change that. And when you talk about an NFT, you only add the word token, it makes it digital. So anything that you see that is not interchangeable with something else, you can link that to a digital code which is registered on the blockchain. So that piece of code is an NFT. And it has many, many use cases. It started with digital art, with CryptoPunks, but now we see a lot of new use cases emerging, and that's also what we specialize in. How can we use this technology to help business? Like you said, what is the business model? How can you grow a business? How can you make human experiences much better using this technology? I think that's a good start to understand this definition.
Okay, so we're already forging ahead. There's a lot of money to be made here. There's a lot of estimates we can go on to as to how big this market is. But going back to Dr. Laura's point, is there sufficient, if any, regulation? Where's the gap? How are regulators responding to this world? Are there any examples where regulators have actually taken a positive first step, or at the moment is it just market driven?
That should be me. There's a lot of regulation happening, but not exactly in the metaverse. So the metaverse initially started in the gaming industry. And the smart contracts are actually the rules of the game that have been implemented within the gaming industry. Nowadays, we can code the smart contracts. There's software for that, Solidity. Any Java, C++ developer is aware of it. A simple smart contract would include probably less than 30 lines of code. However, when we discuss about regulation goes mostly into the substantive part of things. So just to give you a few examples that happened in the recent month. Recently, just this month in November, the DFSA, which is the financial regulator in the IFC, has actually issued a regulation on crypto tokens, which is different than the already existing regulation on investment tokens and derivatives. Then in other jurisdictions, say in the United States of America, the SEC, the Securities and Exchange Commission, has recently ruled that digital assets in general can be considered securities, and they passed the regulatory tests in the US in order to be considered securities. In the EU, the ESMA, the financial regulator for the crypto markets, has recently dealt with the new risks that are involved by the financial technology and the crypto assets in general, digital assets in general, and discovered that there are two types of risk. It's the risk of volatility, because there's a risk of speculation when digital assets are involved, especially, let's say, cryptocurrencies. But at the same time, there's the risk of design, and then the risk of coding, which implies different other elements that would need to be considered from a strictly legal point of view. In the UK, an amendment to the Financial Services Market Bill has just been passed in the House of Commons. So regulation does exist, and we are discussing about what happened in the past 1 or 2 months. But again, this regulation reflects how the regulatory authorities look at the substantive part of things, not at the metaverse. The metaverse itself is a new sphere. And then who has the metaverse, or who develops applications, ownership, or whatever, let's say, transaction in the metaverse, needs to rely on a set of rules. So for now, for example, if you think about the blockchain technology, is based on ledgers. So when I let's say, code a contract in Solidity, put it in the Ethereum blockchain, there is a contract that makes the rule of the game, and the code is the law. The network actually mediates what is happening in the contract and what is happening, what triggers events, contractual events. But things can be very complicated when, for instance, contracts are complicated. So we already use smart contracts in the shipping industry, in the logistics, in the transport, but this only pertains to a small part of the business, not with the full spectrum, because when we discuss about collateral, securities, not everything can exist in the blockchain. And now we are going to the topic of today, which is arbitration. When you think about arbitration, stricto sensu, arbitration is an alternative method of dispute resolution. So basically I need to have a clause in the contract whereby the parties agree to send the dispute to arbitration. Now, I would like to ask, for example, Koen, who is here with us, whether, let's say, NFT designers or blockchain engineers, let's say, envisage to introduce arbitration clauses in the contracts, noting that in the metaverse, you don't have, let's say, a specific arbitration body per se to do institutional arbitration, and you don't have courts to enforce the arbitral awards. So that's a curiosity that probably the legal community would like to have a response to.
Well, thank you for that question. I think it's a fascinating question. I think the first thing that we really need to understand if we talk about smart contracts, the name itself might be confusing because the word contract is in there. But a smart contract doesn't always mean it's a legal contract. It could be, but it doesn't have to be. It's like you said, it's a line of codes, and the code is like an instruction manual. Like, what do you do when a certain action has been emerged? It's like an if-then statement. So when I, let's say, want to buy an NFT, if you look at the smart contract or do it in the transport industry, the smart contract might be as basic as, if I pay, the NFT executes that I get something in return. So in that sense, you make something trustless. So you don't have to trust someone else, because automatically the smart contracts executes on an order. So if you're doing transport, the smart contract might say, party A is sending me shipment to location B, let's say from Singapore to Hong Kong. The moment that the shipment arrives in Hong Kong, the smart contract automatically transfers the payment or ships something back in return or does something like that. So in that sense, you have to be very careful and determine what is the use case of the smart contract. So you also automate the entire system. Like I said, trying to be as trustless as you can be, so you can trust the technology. If you code the smart contract well, hopefully there should not be any legal issues. But of course, it requires legal assistance, consultancy, to make sure that the smart contract is coded correctly and that everything within the use case and the journey of a certain contract is taken care of. So hopefully we can avoid legal disputes by starting early with being legally involved and use arbitration to code and make sure the smart contract is done correctly.
Yeah, I think that's exactly the thing. Smart contracts, as you said, you can't really treat them as existing contracts where we can amend them while they're working. But the thing is that when the smart contract does something, it's an instant process. It's the best example that I've heard is it's like a gumball machine. Imagine you go to the mall and you want to buy a gumball. You have a 1 dirham coin. You know how the system works. You put it in, you turn it, and having the coin in there allows it to turn in a way that a gumball comes through. It's that simple. It's like, if we're making a transaction and you have an NFT, a token, or a cryptocurrency, and I have a different cryptocurrency, and you've said that you're gonna sell it for this amount. If I put my amount of cryptocurrency here, it just automatically executes the transaction. You can't stop it. It's just like the gumball machine. You can't sue the gumball machine and make it give you money. But you could say that, this gumball machine was coded wrongly. It didn't work. I put my coin in there and I never got any gumballs. Or, maybe you get 2 gumballs and the machine owner comes after you and says, give me my gumball back. As silly as that is. So I really think that the biggest thing is that before the actual smart contract is coded, if it's something between 2 parties, then that has to be audited. And that's, again, not really a lawyer process at that stage, but the auditing firms are going to have potentially liability there, and that's something to consider, and that might include having liability insurance, etc. And then an agreement of what the smart contract is meant to do. So if it does malfunction, then there's an understanding of who is liable, who has to pay back to the other party if the smart contract went against. Because I think in the best case, this is something that is maybe not just trustless, but just something that's also just efficient. So if it does malfunction or interact in a way that's not intended, that can be fixed after.
What else do coders have in mind in terms of legal issues here? So who sets the rules of the game? How important are these platforms, Decentraland and others? So we're talking about creating smart contracts. They're doing this. Are we doing it in a vacuum? What's the general move towards consensus here? What are the key legal issues, if that are being considered?
I would give the first part of the answer, probably the other panelists would give the rest. So I would discuss from a strictly legal perspective. I would go back to what I've said in the beginning. What's the business model? Because if you discuss about Meta, Meta is a platform that has a set of rules. If you discuss about Decentraland, the same, is ruled by, or simply said, administered by a decentralized autonomous organization. These organizations at this particular point are not that, let's say, advanced, I think it's the right word to say, to look into disputes per se. However, disputes related to metaverse do exist because there's a lot of consumer legislation in jurisdictions where, let's say, more nodes are concentrated, such as the US, right? There's a lot of consumer protection legislation that would allow disputes in between the consumer, the user of the platform, and the platform itself. There's a form of tortious liability that may appear over there, as well as a contractual liability. But at the same time, and I think that the focus here is to discuss how inter-user disputes are going to be ruled over. So in the current state of affairs today, Decentraland or Roblox, yeah, they do not have the arm that litigates or rules over litigation matters. There are, let's say, simple rules that apply to inter-user interactions. Most of these are made by the platforms themselves, right? So, for example, when you join Decentraland, you have to click that you accept a set of terms and conditions. When you use Facebook or Meta, yeah, you have to click that you accept a set of terms and conditions, and more or less, that's it. So, a dispute resolution in the metaverse per se, yeah, is a non-concept. So, every dispute that you have over there finally goes back to our human link, to the traditional methods of dispute resolution in here. Because in UAE, we have a case, for instance, which is quite impressive. 608 bitcoins have been transferred as consideration, part of a contract. Yeah, when the counterparty who received the consideration was about to perform, this thing didn't happen. And obviously that led to a dispute that was under the quorum of Dubai courts. Dubai courts made the initial owner of the 608 bitcoins, like a lot of money, lose the case because he couldn't prove ownership of the crypto wallet. So basically, if we look into the realm of this business model, yeah, provided that it has a private origin, Meta or Decentraland or Sandbox are created by private entities. They don't have, let's say, a governmental backup to be considered laws. They are a set of contractual rules that at this point have no other way of being enforced rather than being paralleled back up by the traditional system of law, which obviously is not sufficient because it's a new dimension that we're discussing about. And you may have, let's say, in the litigation realm, solutions that for people that are active in the metaverse, like our speakers here, would look obsolete or would look like anomalies. But this is when, let's say, technology has an advancement that the legal spectrum doesn't have. So in an ideal society, at first we would develop the law and then the technology. But in our world today, it's exactly the other way around. Yeah. So to answer the question, who makes the rules in the metaverse? Yeah. This is, if you want to call it like that, from a public law perspective, a very new concept, yet unknown. Yeah, because we do not have any regime to borrow from. We have to develop everything from the beginning. Yeah. The digital economy is huge, but when you discuss about the IP, about the law of the sea, about the outer space law of the sea had a custom that, let's say, operated as basis for hundreds of years. The regime of, let's say, transit through the international narrows, for example, right? Or the package deals that led to the creation of the Montego Bay Convention on the Law of the Sea, the UNCLOS Treaty. In the outer space, for example, the engine that moves the regulation was actually the stop of the arms race in outer space. That's how the Outer Space Treaty has been signed in 1967. And it's one of the instruments with the fastest entry into force. It's a matter of 8-9 months, which is rarely happening in the UN system, which is very plain and consensual. Now, when we discuss about, for example, Antarctica, which is another regime outside the jurisdiction of states, the regime developed around the moratorium of exploiting resources. Now, when we discuss about the metaverse, everything is new. So none of these existing regimes that exist in the law today can be implemented stricto sensu. It's not possible. So the question goes back to the beginning. What is the business model of the metaverse, right? So for now, you have software. You have software that makes the rules. You have the code. People have issues of privacy, of let's say, security of data breaches, of a lot of other, let's say, elements that appear into the legal sphere. But what happens if you have a dispute over there? So for now, my conclusion is that a delimitation, a strict delimitation from the traditional system of dispute resolution has not been made because there's no rules applicable as such.
So Elias and Cohen, from a non-legal perspective, how do you feel about where things are going? And in terms of confidence as well, when we're talking about IP data protection, I mean, the Binance crash, FTX collapse, I mean, you know, as part of this ecosystem, it does sometimes cause people to take a step back. What do you want to see in this space before we get lawyers involved in resolving disputes? What do you want to see in terms of regulation or KYC? What do you want to see in this space to give more confidence?
Yeah, right, yeah. Now you're looking at him, so I'm sure if you address it to me. Well, I think the first thing, if you look at this space altogether, even though it emerged more than 10 years ago, most people are still very, very new to this new world. NFTs, Metaverse, cryptos, most people have no idea what it really means and how complex it is. And like Laura shared, there's so many complexities and things to consider once you engage in this new world and using these technologies. That's why there's, in that sense, the hashtag that's one of the most popular used in this space is DYOR, do your own research. You have to really do your due diligence when you start exploring this space. You have to do your research. What are the parties that you involve yourself with? Who's your other party? Can you trust that person? So there's a lot of things you can, in that sense, already start doing yourself. Because I think it's still considered as the wild, wild west. You're going into an empty space and you have no idea who you're going to meet. What are their intentions? Can you trust them? Are they armed? Are they not armed? So you have to be careful in that sense. So you can't just basically trust anyone who's on the other side of basically a computer screen. Yeah, do you like to see regulation? Yes, that would really help. At the same time, the market goes so fast, sometimes it's difficult to understand the complexity of the new things that people are talking about. I'm talking now to people on Telegram, and they're launching many businesses at the same time using blockchain technology. Is there a law? No, there is not. Would they like a law? Sometimes yes, sometimes no. It depends on the business model. So there's always these things that go back and forth. Yes, you want regulation, but you also want to move forward and be the first one to market or provide a service or a solution to your target audience. So I think if you go back to the case of the Bitcoins, KYC definitely helps because you can register your name, your identity is linked to a certain wallet. At the same time, people want to move away from that. So there's always a continuum. Some people like the privacy, some people like to be publicly known being a holder of all these tokens. So I think it's very complex. So I think it's based on a per use case. Do you want the regulation to be in place? I think in many cases there can be arguments made before that, but also against that. So I think you have to see per business model, per use case, is regulation needed? Who will be the one that is having that authority to make sure that the regulation is followed and that disputes can be managed? And sometimes it's not possible yet because you're so advanced in what you're doing that it's almost impossible to have a regulation in place at that time.
Thank you. Yes.
If I can just add onto this discussion a couple points, just so everyone's clear on how things work in this metaverse space. We're talking about who we're dealing with, knowing who we're dealing with, and legal remedies. The reality is that if you go into a metaverse, whether it's Sandbox or Decentraland, 99% or 95% of the time, you're interacting with someone, or even just in any way interacting in the blockchain environment. If it's not a centralized company, you do not know on the other side of the smart contract. You do not know, and that's actually irrelevant because it's the smart contract that does the actual transaction, not the other party. And you do not know who wrote the smart contract. You don't know who owns a piece of land in the metaverse because these are blockchain identities. You know, you can follow the chain and you can see that, okay, this account that owns this piece of land also owns this and also owns this, and these are the past of their transactions. You can see all the transactions they've ever done. You can trace all of that if you know how to do that and look, but it's not necessarily connected to any living person or any entity, and you can't place what jurisdiction they may be in, who they might be, and the only way to even attempt to do that, if they're not going out of their way to, you know, tell you who they are and prove that, is to have an international, police investigation where, you can track where, where the money came from an exchange and then who deposited that, and even that's a months-long process. So it's we can talk about these concepts of arbitration but it's so difficult to even start when really you're dealing, blindly. You have no idea. It's across borders, and fundamentally these things aren't really happening in any jurisdiction. Yes, theoretically they are in some jurisdiction because someone coded the smart contract somewhere, someone who owns the account has their tax domicile somewhere, but no one actually knows, and it's impossible to figure out. With that, I'm going to get to the history of it, and I'll introduce my latest book here very quickly. So this is Blockland, and it's a history, the first decade of the industry, and the history of blockchain, where it actually came from. In the late 90s, there was a group of people on the west coast of the US. They were called cypherpunks. And they were some of the early tech funders from Silicon Valley. And they had this idea that we could create code that will replace government. We will replace government, the whole concept of human government, because humans are fallible and because humans might change their mind. Humans might change the law later. Machines won't. Machines, we can code it like this and it'll be 1,000 years and no one will ever change it, and it'll be this thing above humanity that arbitrates right from wrong. And this was this technocratic ideology that spawned Bitcoin, and that's where Bitcoin was released into this community, and it was released as a currency, and the goal of this movement for decades was to have a decentralized currency that governments couldn't control or influence. And that was the whole idea of Bitcoin, that now you can have a currency that is freely available, that can't be legislated. It doesn't have policy attached to it. It's something above human control, because that's kind of where this comes from. And this is a massive, massive challenge for any kind of law, because it's fundamentally almost resistant to humans saying this is right and this is wrong, because it is a virtual kind of physics.
Well, I can see some lawyers shuddering at the very thought of this, trying to bring this down to earth. When we talk about arbitration in the metaverse, we can obviously touch on some different aspects. You might have seen the announcement that ADGM is doing mediation in the metaverse. It effectively means they have a virtual extension of the ADGM, and it will replicate what it would be like being there, but in a nice environment. Maybe the arbitrators have six packs in that side of things. But
or something else.
Or something else, exactly. A dragon, why not? But then, if we're talking about arbitration in the metaverse in that sense, obviously there's potential where we could go up against one of these platforms. There could be a dispute where we go, where we take action there. The point was made, in some cases, the mere concept of going against someone is irrelevant if you have a smart contract which automatically executes what is the business intentions. But if we talk about arbitration in the metaverse in a legal sense, where are we? What can arbitration bring to the table, Laura? If anything, is the way that arbitration we think of as flexible, and you can choose the seat, you can have different laws, but what do we do here? Can arbitration offer much to the metaverse?
I think part of the concept of arbitration would need to be reinvented, because now in the metaverse, the code is the law. So if somebody would come to ask what is Lex Arbitri or what is the seat, obviously in the existing state of affairs, the seat determines the court of judiciary control, the one that does the enforcement. But in the metaverse, the network does that, the code does that. So basically, the architects of the metaverse would need to consider an alternative dispute resolution mechanism or a dispute resolution mechanism that is proprietary to the metaverse. Because there's a wide possibility that the load of disputes on blockchain to be essentially lower than what we have in the day-to-day life. Because most of the contracts are self-executing. So when they are coded correctly, there's obviously a very small margin of a situation being prone to dispute. But arbitration is created in our world, in the 3D world, as an alternative dispute resolution method. So in the metaverse, when the code is the law, yeah, it would be very, let's say, difficult to create alternative dispute resolution methods. Or it would be easy if the code is created for that particular thing. Because normally when you have a contract that is deployed in the blockchain, the network, the blockchain mediates, solves the dispute or the quasi-dispute, because it's not exactly a dispute. The contract is self-executory. But the problem that we have now in this intermediary phase, because we are not in the initial state of our society and we are not completely in the metaverse, we are in a, let's say, hybrid stage. You see that most of the disputes are mixed. Because obviously, and I think this clear delimitation cannot be made, because for as long as, for example, the SEC in the US considers the crypto tokens as being securities, yeah, you can in many cases have a mixed kind of contract that implies a traditional contract and a contract in the metaverse or executable through the blockchain. And at that point, it's very unlikely that you can simply depart from the traditional system of dispute resolution that we have now. But for the future, when all the economy or a large part of it, a large part of the society would go entirely digital or entirely in the metaverse, obviously the answer is that you have to develop code in order to self-execute disputes on contracts. So probably many of the middlemen would disappear, because that's what the decentralized network did, yeah? So all the middlemen, for example, if, for instance, for a very basic example, if I need now a power of attorney to be issued in Germany to be valid in the UAE, I need 2 months of work, right? Notarization, signatures, etc., stamps from the embassy, stamps from the Ministry of Foreign Affairs, yeah? If you have the blockchain technology, all these middlemen are out. And it's a matter of seconds. And the regulators already picked on the idea, because now there's a lot of, let's say, interbanking transactions that are happening in the blockchain. Instead of having, let's say, an interbank transfer operating in days, you have it now operating in minutes, in seconds. So at that time, when we move entirely into this decentralized economy, if this would ever exist, then the code would obviously be the one mediating disputes and solving disputes. The human intervention would probably not be needed.
And yes, maybe to get your perspective, are there lessons to be learned from the experience of eBay, where most of these smaller level disputes are actually managed online through the mechanism, the framework that's been set in place? What's your take on this? Are lawyers a hindrance here? Or what's your take on all this?
Well, I mean, I don't want to talk too much bad about lawyers. I mean, I have a, you know,
They
I'm
fight
in
hard,
the
don't
industry
mess-
myself, and I'm intending to start my PhD in international law on this metaverse stuff in January. So I'm not that far myself, but the thing with eBay is that it's a closed system. it actually has control. It has government-like control over the affairs of the buyers in this context. And what that means in practice is that you could almost think of it like a smart contract. Not in a blockchain sense, but it's like when you agree to bid, it locks a certain amount of money from your account. You have to have that money in your account, and then it kind of locks it. And then if it's accepted, it gets moved, and then there's a certain time period, and then once you actually receive the item and they're happy with it, then the seller gets that. And at some point it moves into their PayPal and their bank account, and they can withdraw it, and then eBay can't get it back anymore. So there's a system like that. But the thing with a smart contract is that this execution is generally immediate. And just like after you withdraw your money from PayPal and from your bank account and from an ATM, eBay really can't claw it back. And also, by being on this platform, both the seller and the buyer agree to be part of this kind of arbitration system within eBay. And also this platform very critically has KYC. They actually know who the sellers are. eBay has the identity, the address, they know the actual country these people live in. Whereas a blockchain platform, A, they don't know any of this information, and B, they don't necessarily even have any employees. I mean, I could write, I personally couldn't write, but someone could write a smart contract today and it would be operating 10 years from now. And there's no human involved necessarily. Now, you could have a blockchain protocol, an ecosystem, but that would be closer to a centralized entity, kind of like a centralized exchange, kind of like finance, but that's a hybrid model, I would say.
Okay, no, fair enough. And if we bring it back down to earth, where arbitrators have a lot to offer, it's essentially if there's a dispute and you have crypto assets. So from an investment perspective, if I bring you in, Cohen, what are the lessons we've seen here where disputes involve these kind of assets online? What is your guidance or your advice in this space? What would you like to see happen?
Well, from a personal perspective, what I would like to see happen sometimes is maybe transparency in investing in certain projects. I think 2017, 2018 was a massive example, and time to learn from. If you saw all the ICO's initial coin offerings where everyone and his grandmother was launching a coin and they were hyping it, a lot of marketing, and a lot of people jumped on it because it was a good story. A lot of people got wrecked, as they call that. They lost all their money. Some were rug pulls, meaning they just disappeared. They said, here's this, let's call it token XYZ. It's going to do this, this, and this. Please help us build this technology, invest in it. And a lot of people thought like, oh, that sounds like a great story. It's going to make me rich. So let's go for it. And then you see a coin, because people believe it, goes up quickly in price. And people jump on it. But as soon as the price goes up, a lot of people see like, hey, I put in $10,000, now it's worth $1 million. Let's take everything out. And you see the market collapses instantly again. So in that sense, it would of course help if there's transparency to really see who are the people behind it. Can we audit what they're promising? Is there something like put an escrow, their own tokenomics, who holds those tokens? Because a lot of people, they sell tokens and then they keep tokens themselves that they also can instantly sell for a profit. So that transparency is also something, of course, that you have to do yourself in terms of doing your research. But I think that was the biggest lesson a few years ago. The people thought like, hey, it's a good story, but in the end they didn't know who's behind it. Can they trust those people? And like you said, people change their mind. People go from working in the basement of their parents to become multimillionaires overnight. Do you still have the passion to succeed? Or do you see like, hey, I'm a multimillionaire now, I take out all the money and run, which is possible if no one knows your identity. Coming back to that, I think now we already see a huge evolution in that. In the NFT space, there's projects still where people don't show their faces. They have like masked identities using avatars, but you'll see more and more people that show their LinkedIn IDs, that show pictures of themselves. You can actually track who is this person. So at least it gives you a bit more trust knowing who's behind the other side of the smart contract, behind the project. Of course, it still doesn't mean anything. They're not legally obliged to keep their word if there's no binding contract. But I think these things help when you invest.
Thank you. Dr. Laura, anything to add to that?
there will be a lot of things to say. As lawyers, we always have things to say. But then listening to Elias and Kuhn, obviously we go back to the initial question: what is the business model in the metaverse? Because if we look into the regulation now, everything is looking into KYC, AML, who can trade. The Hong Kong, let's say, Securities Commission has recently opened the metaverse from qualified investors to retail investors, subject to certain brackets that need to be filled in: KYC, AML, identity disclosure, etc. So the idea, from my point of view, the idea of a completely decentralized metaverse is far from being a reality. Because when you deal with a platform, let's say a sandbox or you name it, it has a set of terms and conditions. From the traditional legal system perspective, the users of this platform are consumers. And they already sit on a platform of rights that is created by the consumer protection legislations in this world. So the idea of having something completely different than we have today, is, I would say, a proposal de lege ferenda, as we say as lawyers, something for the future. But this is a model that would need to be invented. So for me, as I see it, as a legal practitioner, I think it's very predictable that governments and regulators in this world would step in order to create the rules of the game. And this is already happening because, for instance, if we look into what is happening in the US, which is very developed from this point of view as jurisdiction, the SEC came and made a very clear statement that all these investments in the metaverse need to be done through regulated platforms. In order to be secure, in order to entitle the users to specific rights and to impose on them a specific, let's say, set of obligations. This doesn't mean that the tokens are entirely regulated, but the way in which governments look at it is through the filter of this regulation. So, yeah. The idea, let's say, of a dystopian projection did not materialize. The idea of, let's say, a new world does materialize, but its complete decentralization in front of the current regulatory system is very far from reality. Because obviously a government would not lose its powers in, let's say, a potential spectrum that for now brings transactions on $5-8 billion per year. Yeah, so it's a business. So as we jump in, the governments would jump in as well.
Brilliant. I'll go back to Elias. Can you just comment on some of the transactions we've seen recently in the gaming space and the art space with NFTs? What's your thoughts on how that's developing? What's some of the lessons there to protect investors? There seems to be rising confidence. What's some of the lessons we can draw from what we've seen recently?
Certainly, I mean, that's a big area to draw from here. But from the perspective of protecting investors, so in the last year, we had something called the NFT boom bubble. People were creating NFTs, these digital pictures primarily, and selling them. And there were these hype bubbles. There were hundreds of collections of different animal pictures. Think of it like trading stickers or something like this, or trading cards, of which there are limited editions of different types of animals and monsters. And people were, bidding in, trading immense numbers of hundreds of millions of dollars in these. And it was all being done primarily without any kind of oversight. So anyone, any 15-year-old could have created a collection, sold them, taken a bunch of money, not even given out the pictures at the end. This happened. It's as simple as that. They took millions of dollars and then they just disappeared, and no one ever knew who created these. And even if they did give out the pictures, usually the price ended up dropping 95%. But for education's sake, the most interesting ones were called CryptoPunks and Bored Apes. You may have heard of them. They're pictures of these pixelated guys. CryptoPunks and Bored Apes are pictures of monkeys, and that's the age-old, well, not old, but this idea, this meme, this joke that, trading monkey pictures on the internet. So Bored Apes, they're a collection of 10,000 monkey pictures, literally, and they started off at $300 each, and now they trade for about $100,000 each. And at the peak, they traded for a minimum, for the cheapest ones, about $500,000 or $450,000 each. And it's a very interesting project because a huge company and a brand has formed around it. They've made their own metaverse where all the monkey owners have gotten metaverse land, and they've gotten other kinds of monkeys, and then monkey dogs, and even the monkey dogs are worth maybe $10,000 each. And it's created this whole market. And what's interesting, and then they even released a token. They released a monkey token, and everyone who owned a monkey worth $400,000 got $100,000 of free monkey tokens that they could have sold for, actual dollars immediately. It was insane, and I was in it. But what's really interesting is that company has now started doing a KYC thing, where they're trying to get owners of monkeys KYC'd in conjunction with other metaverse brands. Animoca Brands is a metaverse gaming company, and they've been registering, allowing the monkey owners to register so that they can then receive airdrops. And I think that's an interesting development, that it's becoming less anonymous, if that makes sense.
Great, Koen, I'd like to hear your perspective. In fact, you have an announcement. You're doing NFT for a law firm here in the UAE. I'd like to hear a bit about that. And also real estate in the metaverse. From a legal perspective, keeping in mind arbitration in the metaverse, what are your thoughts on that?
Let's start with, to build curiosity a little bit longer, let's start with the metaverse question. I think if you look at real estate in the metaverse, you really have to look at first, why are you interested or in buying and owning a piece of real estate in the metaverse? What is the use case? If you, like you said, go back to the business model. Some people buy the speculative investment, hey, it's going up, so let's throw some money in and hopefully it returns much more than I put in. Of course, that's one way, very speculative. At the other hand, the metaverse as it's emerging is meant to be a place where people can interact with each other, where they can live, where they can generate business, where they can show events or concerts, or even showcase their products and sell them digitally or also in the physical world. So first, I think you would answer that question, like, why do I want to own a piece of real estate in the metaverse? And also, what is your time perspective? Do I want to own it for a few minutes, which is possible, hours, days, or years? Because some people that start investing, they actually invest with money they cannot lose. So their time perspective is very limited, because they know next month they have to pay a mortgage or rent. So they're risking money that they can't afford to lose. So they get very emotional, which I think is always a bad thing to do if you're an investor and going into these type of industries. But if you understand, like, okay, why am I investing? This is my time perspective, my time frame, so I'm willing to put effort, wait, see how this emerges. And then you can think about, okay, if I have this purpose for the real estate, then what do I need to get? Like, if you love the beach, you buy a property at the beach. If you like skiing, you go to the mountains. If you don't decide on this first, then yeah, you're just throwing basically paint on the wall, see what sticks, and hope it does well. So really start your research, why do I invest? Then you look into what should I invest in? And of course, it's a whole process, and then you can look into the how of things, because the how is very easy. I mean, it's a 4-step process to buy real estate in the metaverse. But the other steps are actually what make you successful or make you lose all your investments in that sense. Then the second question, of course, very interesting, the announcement. Today, Altamimi and company is launching their first NFT collection. They're the first law firm in the Middle East, and one of the first in the world that is actually doing something with NFTs. So it's very exciting. We've been partnering with them for the last couple of months, working together to bring this collection to fruition. It's a collection of 950 unique art pieces that actually showcase their 30-year of history of law update, which is a newsletter that they bring out on a frequent basis that gives all kinds of insights about the law in different industries. So the actual art pieces that you can actually mint today for free. So hopefully you also get a chance, if they're still available today, in the afternoon, you can actually get them. It's a way to give back to the community. It's actually the front page of their magazines, which is beautifully designed art. I had the pleasure of already getting two myself, because everyone has a limit of getting 2 NFTs themselves. So this is also, I think, a very good first step. If you're not familiar yet with this space, it's in that sense risk-free, it's free. So take those steps, actually creating a wallet, getting those NFTs. So it's a very nice learning experience to start understanding what is possible in this new space. And I think Ultimimi is, of course, doing this to connect community. And if you're actually one of the 16 lucky ones that gets a cover with a golden frame, you also get benefits from that. So you can get access to legal experts. So it's helping them. Sorry? No, we did with our team.
What's in the back?
Sorry?
What's in the back? Yeah.
What do you mean? What's in the back?
Okay, benefits are there, but in the back, okay, if you don't keep it, I'm a lawyer as well, so how much?
Well, what's in the back? The moment we quoted it, like initially, there's only 500 available of the 950 for private, so basically they're key clients. When you link your wallet, you can basically click a button that says mint now, and the smart contract sends you a random. Oh no, actually, sorry, you can choose from the collection which NFT you like, so which unique art piece that you like to get. There's a whole collection online from, like I said, from 30 years of history, so there's different industries, different art collections you can choose from. So the smart contract executes, you click mint, so it's sending it to your wallet. So in that sense, there's not much complexity or secrets behind that. No arbitration.
This looks like a good
Not yet.
This is a good BD user case. You could see there, integrating with the existing framework. Going back to disputes, Dr. Lauren, I think it was very helpful earlier. We've got these assets. This one's free, for example. Others have gone for thousands of dollars and more. What are some of the lessons learned? You mentioned some of the cases. What does the case law, or at least the general discussions, tell us about disputes where we have these kind of assets? What's some of the case law telling us so far that we haven't touched on already?
The full idea behind this kind of investments, NFTs in general, is the fact that they are unique. And the investments in this sphere, as of now, are largely speculative, in the sense that I buy an asset on the premises that in the future its value is going to increase. So that's more or less the level of investment that you have now in this sphere. But we are envisaging a world that is much more diverse from a legal perspective. As said, now we are using smart contracts in conjunction with a number of paper contracts or digital contracts, what we have available today. The contracts can reach a very, very wide complexity of legal elements and imply actually a work of interpretation. And this work of interpretation is now done via the courts. It's not the lawyers, it's not the parties, it's the courts. They interpret and apply these contracts in case of, let's say, dispute. When it comes to case law, the regulation that is currently enacted is based on case law, because this new move of the SAC in the US, which gathered a lot of field with considering the crypto tokens as securities, came based on a case. It's a famous case of Ian Balina, who did nothing more, nothing less than creating a currency with a beautiful marketing around it. And then people invested. The ICO came, it was published in all the online spheres, Facebook, Instagram, etc. People invested and lost their money. And it's a very, very typical case. And the holding of this, let's say, business was a non-regulated company incorporated offshore. So So the financial regulators came into the picture and said this needs to stop, because for as long as you invest in order to get money, yeah, the mechanism of investment is very similar with investing in stock exchange, yeah. All this investment need to happen in a regulated domain, and this model transboards in all the regulation that you know. For example, if you look into the new rule book of the DFSA, they recognize by name crypto tokens. So these are lawful investments. Whatever is not on the list needs to be added to the list, subject to passing the compliance checks within the DFSA rule book or manuals. So what we see is that when you wish to invest in this space, or when you wish to benefit from the scarcity of these NFTs, yeah, you'd have to go through a regulated platform. So for as long as this platform is regulated by a national government or international intergovernmental organization, as it is the case for the EU, yeah, which has a very, let's say, strict platform in place, yeah, you would benefit from the regulatory tools that that government body brings along. Number two, we see that a lot of investments are happening, for example, when you discuss about Decentraland, Sandbox, are happening through private investments, because these platforms themselves, they are the ones that determine the rules, the terms and conditions of you joining their space. Yeah? So when it comes to this projection to disputes, to arbitration in this case, you have, as said, possible IP disputes, possible IP monetization disputes. This can be subject to arbitration stricto sensu, as we have it today. You may have consumer disputes, or you may have tort-based disputes in between, let's say, the user and a specific platform. Yeah, this also can be, not in all cases, but can be arbitrable in the realm that we have today. If no arbitration, then definitely the traditional courts would do the trick. And then probably the most important ones are the inter-users disputes. And that's where, let's say, the beauty of this subject actually appears. Because when you don't have, let's say, the code to do it for you, the question, and I believe this is subject that this subject would be responded by us in one of the future meetings, I would say, who would rule over that dispute? Because when you go into the metaverse, you deal with VR, AI, etc. But if the code doesn't do it, then who would do it? So now, to conclude, I go back to the novel of Snow Crash that Elias was saying about in the beginning. Yeah, one of the most important, or the phrases that I enjoyed reading in that book is actually, and it started with the command system. So the command system is the network. The same thing happened when Satoshi, or allegedly him, did the blockchain. And this is a topic that I read about in your book, in this one. So basically, the architects of Metaverse leave from the premises that the world needs to be reinvented. But there's a lot of resistance back here, yeah, that obviously doesn't allow that to happen. So now it depends for everybody where they wish to join, in the regulated or in the non-regulated sphere. But obviously, as a lawyer, I would need to be politically correct and say that if you really want to have a proper enforcement of your right in a dispute, and obviously you cannot literally depart from these regulated or regulatory models that converge, I see, in most of the legislations these days.
Thank you. Before we open for questions, I'd just like to ask Elias, until we get a chance to read your book, can you reflect on what are some of the key lessons learned? What does the future hold, especially for the legal community? What can you share with us, crystal balling as best as possible?
Well, I mean, my big thesis that I'm going into my PhD with is the idea that, and which you already spoke on, is that we have international law which underpins most things, and as we have had technological advancements, we've had new areas of international law to develop to deal with these situations in which we can act and have the ability to act outside of the traditional scope of sovereign territory and governance and control and legislation, as however we might call it, whether it's through maritime law when we could sail on the open seas, through outer space law when we could go to other planets, solar into orbit, and now with the metaverse, I believe we will have something akin to metaverse or blockchain law, which will deal with the fact that it is possible for anyone to move any amount of money and value that has consequences in the real world into a space where no government, no earthly authority can take it away. If you so don't decide to give it to them and aren't dumb and let them. And that is a fundamentally disruptive concept, and my view since 2013 has been that this actually changes the very basic social contract that is laid out, for the last hundreds of years, because historically a government can take money out of your bank account, they can search your backyard in case you bury some gold there, they can confiscate things, and now you can't. So this thing, it's a radical development, and we're gonna have to deal with this new reality and ability that exists.
I'm just now thinking of rechanging the Dubai government course on liquidated damages and remedies. It's very awkward. But Cohen, can you add your thoughts, final lessons learned, looking to the future?
Looking forward to the future, I think there's still a lot of questions that need to be answered. But like I said before, I think if you look at the future of arbitration in this industry, it really starts before. So I think lawyers, in that sense, if you want to be involved, should start at the beginning and not try to dissolve disputes. I think it really helps if you start building the use case, building the business model, and link that to smart contracts. You also should already have a legal perspective in there if necessary for the certain transaction or for the interaction that's going to be conducted, and like we talked about, it's going to be automatically executed. Of course, if there's a failure of the gumball machine, what happens? What are the legal ramifications of that? I think it's going to be a future of teamwork in that sense, so people should understand the use case from a blockchain perspective, from a business perspective, from a user interaction perspective, but also from a legal perspective. So I think that's what I see for the future in terms of how that moves forward.
That's quite clear. Dr. Laura, final remarks from you.
Thank you for coming. There would be a lot of things to say, actually. I'm thinking about what Elias said, and that's a good food for thought for all lawyers, because if you look at the system of international law now, which is based on the equality of sovereign states, in the metaverse, this model of nation state or of sovereign state evaporates, it dilutes, right? So if the code is to replace the public international law sphere, that's a very good question moving forward, but obviously it's a challenge to various models of governance. If we look now into what exists into the international law, I would say that if you look into the history of the United Nations General Assembly, whenever a treaty was to be passed, each state, irrespective of the size, would have a vote. The smaller states, which are more numerous, would probably oppose their quantity to the political power of, let's say, the G7, G8, P5, or whoever is a large state player. But I doubt that this is going to happen in the metaverse. So this full construction, which is the public international law created after, let's say more particularly after 1945, the United Nations Charter, I think it's going to be heavily challenged. And with this in mind, I think I'll start writing again. I haven't written in a very long time, but there's a lot of things to say about the blockchain law in this new sphere, which is the metaverse, and especially the resistance that this new sphere would face from the actual models of governance that traditionally ruled the world for a long time. I'm thinking now about how the criminal law changed, because after the Spanish Revolution, the full inquiry in criminal law changed from being inquisitorial into adversarial. So that was a huge and the first limitation in the power of a regulator. Nowadays, the power of regulators is tremendously challenged. And then when you look into the metaverse, then obviously there's a lot of proposals, a lot of areas where you can explore. And what interests me the most is how much resistance the actual model of governance would, let's say, bring in. Like if you look into arbitration per se, now we've had the New York Convention, which is enforceable in 170 states. That's what makes arbitration so appealing for parties in a dispute. Then when you discuss about the metaverse, where we don't have a territory, yeah, and the enforcement will actually happen in a network of computers, then probably the questions appear in terms of necessity, limits, why is it needed, and who would actually do it. Yeah. So if you look closely into the picture, I go back to the same conclusion. What is the business model?
Yeah.
If I can say one more thing, I apologize.
All right, let's.
This might scare you. I apologize for that. But if we look at the idea of what is a state, what makes a state, what is it composed of? A practical, de facto, defensible territory, assets, population, a mutual. I mean, if you look at these, most of them, actually, you can make the argument. You can begin to make the argument that the metaverse is a state by itself, because you can, you can take the majority of your assets and you can move it into the metaverse. You can work in the metaverse. You can earn an income from the metaverse, and no government can take that away. I mean that. What's the real?
But whose metaverse is it? I don't know if I trust Meta, but anyway, let's open for questions. I think, Dr. You've opened the floor to a lot of questions. So can I start over there, please? Yeah.
Thank you very much, Paresh Kaflani. A very rich panel discussion, smart contracts as law, NFTs, and also I like your concept of the metaverse as its own sovereign state. I'll pick up on something that Hussein said about the seat of arbitration and also the ADGM opening up mediation in the metaverse. Do you think that current arbitral institutions are sort of well stocked in order to deal with metaverse disputes, or what advice would you give them to be able to cope or to deal with metaverse disputes going into the future?
Dr. Laura, I think that's for you.
Yeah, I think it's for me.
Hello? Yeah. Being equipped or not being equipped is actually a very good question, because being equipped to deal with a dispute is highly dependent on the nature of that dispute. If you have a traditional contract where you have digital assets as securities or as consideration, of course, any arbitration institution is equipped to deal with that. Now, food for thought for lawyers who draft contracts that include arbitration clauses is to choose a seat or a Lex Arbitri, which is equipped by itself to deal with disputes. So the arbitration institution would do it. But in the end, what the arbitrator applies into the dispute, yeah, is a system of law that may be or may not be equipped to deal with digital assets, etc. If you look at Dubai becomes the place for that. You have the DFSA, the new rule book, you have the VARA, the Virtual Assets Regulatory Authority, you have the ADGM, you have the courts of the future, so this is the place to be for that. But then the question appears in the judiciary control stage. Where do you do the enforcement? Because if, let's say, I have a token which is brought as security into a contract, and then if, let's say, I lose the case, then the court needs to enforce something related to that token. And that token may be, let's say, in my possession, but will need to be transferred to somebody else because I lost the case. It's part of the damage that I need to pay. That's where the question actually appears, because when the token is coded into this blockchain via a smart contract, obviously this contract is immutable. So therefore, let's say the legal denomination of this token would need to change. And that's probably the part where a court of judicial control that does execution would have, let's say, a problem. But that would exist, I believe, anywhere in the world. Yeah, hope I responded. Thank you.
Michael Patrick Joyce.
The same, thank you very much. Michael Patrick Joyce, I'm head of 36 Commercial in London. And it's therefore and I'm a barrister, so therefore the question starts in a legal environment, but I'd like to broaden it out a little bit. It starts from what Dr. Laura was saying about regulation and the ultimate irony that here is a central authority of the DFSA seeking to regulate something which started off as libertarian and anarchic. So, and it comes back very much to the point about a new social contract emerging. And I'd be interested to hear the panel's views on whether we're moving to an environment of regulation by the regulated through an element of self-interest, and whether that roots regulation henceforth much more in the private domain rather than in the state domain, with some fundamental challenges if that is the direction of travel.
It's a very articulately put question. I think there was more there than I could absorb immediately, but I think it's going to be both. I think my fundamental thesis of blockchain is that it enables both sides. It means that it maximizes what we could call liberty, the ability to act outside, in the Wild West, but it also maximizes the ability of a governing party, regulator, state, to track transactions, because it's all there forever. The question becomes is where these two systems meet. So the DFSA in Dubai, any regulator here or in Europe or elsewhere, they can build a system that is kind of like a walled garden where they can track everything, control everything, perfectly count all the taxes and everything. But then there's always going to be this interaction point with the wild. Think of it like where the ocean meets the beach. And there's always going to be that kind of waving back and forth. I would say that the majority of players, at least in the foreseeable future, whether they're companies, especially companies and individuals, are probably going to attempt and aim to play by the rules because that's beneficial. Most aren't going to go rogue and try to, leave the system entirely, because that comes with challenges. It's harder to buy real estate. You always have to have the on-ramp and off-ramp. But it is going to enable both, but probably more so towards the government regulators in the, let's say, the near to medium future at least.
Actually, that gives me a little hope that there's a hybrid there between the Wild West and the system.
Can I please add one
Yes.
line to respond to the same question? Actually, I find this question extremely interesting because indeed most of the developments that happen in the metaverse are private, as you very well said, and that's a very good observation. Sandbox, Facebook, Meta are private. So I assume that let's say a national government or an intergovernmental body would not lose the power to regulate this space. So as much as we would like to consider that yes, the code would be the law, it is unlikely that that would happen in the foreseeable future, because there's already a pattern in the regulation that shows us very clearly that no, governments and intergovernmental bodies and even intergovernmental international organizations do step in to make rules. You have already an UNCITRAL model law, you have for a lot of regulation for crypto, you have a lot of initiatives in the European Parliament as to how AI can have legal personality, how can AI be subject to contracts, etc. So I think that the foreseeable future is this hybrid model, but the balance would incline in the favor of the traditional regulators somehow.
Gentleman there, please.
Thank you, Dr. Laura, Colin, and Arias for the enlightening panel. I guess my question kind of touches on arbitration and perhaps cryptocurrencies at first, and forgive my elementary vocabulary in the topic, but when it comes to arbitral enforcement or enforcement of an arbitral award, say for example, onshore UAE, what happens is you would apply for the enforcement of the award, then procedurally the enforcement arm of the court would then write to the central bank to try to identify what the cash assets are of the party against whom enforcement is sought. Do you envision a future where the party against whom enforcement is sought has a digital wallet against kind of where enforcement can be sought against that, or that could be the enforcement asset? I mean, you did mention enforcement, a digital cryptocurrency, say for example, as a security, but I guess that would then lead into the question of anonymity and government encroachment to try to absolve anonymity, so then each person who has a digital wallet or who has a cryptocurrency can be identified. A lot there, but what are your thoughts?
I think you're right, and I think this is going to happen because in the regulation you see a paradigm shift from this freedom, like the Wild West, into people, let's say, that do KYC in order to join a regulated platform or regulated exchange, etc. So obviously, in order for somebody to bring a security, a crypto or a digital assets to a traditional contract, obviously it needs to be regulated, because otherwise this security would need to be registered somewhere. So from the point of view of traditional litigation, it needs to be registered with a traditional regulator, not in the, let's say, with the sandbox or with the Decentraland, etc. These are private bodies, right? So I think that in the foreseeable future, it's very much happening that a crypto asset to be executed, or executable as a security, as part of a consideration, as part of a damage, etc. The problem that appears here is not the substantive part of it. It can be executed, but the question is, for as long as your crypto asset is in a blockchain, how does the traditional court, for example, Dubai courts, as you said, have the power to change the blockchain, which by itself is immutable, and change the ownership of that asset? That is a question. So the problem of enforceability is probably solved. The operational part of it, how is it happening in the coding life, in the day-to-day life? That's a question where we would need to find answers, and that's why we're discussing about the case of 608 bitcoins. This case was, as per my knowledge, as per my information, was in the court of first instance, but you know that court of first instance is not final. So there's judiciary control over it. There's appeal. In the Dubai courts, the appeal is executory, but again, if it reaches cassation, there is also a possibility that the execution would be suspended. So we would need to follow this type of cases of litigation to see how the local courts or how the arbitral bodies deal with this kind of disputes. So for now, it's pretty much new. Right?
And Dr. Laura, forgive me if I may also, and you mentioned security, what happens in a situation where cryptocurrency is not at play at all, and ultimately you're looking to enforce against a party and they do have cryptocurrency, and you want to enforce against the cryptocurrency? And do you foresee a future where the governments would, say, do a comb of everyone that exists within a certain jurisdiction to find out who has cryptocurrencies within their digital wallets, and as counted as a cash asset? Or how does that work? What do you think?
I can tell you how I see it. Okay, so if we look into the legislations that we have now, I think it very much depends on the type of cryptocurrency that person is having, and where is it kept. If it's in a regulated exchange, it's in a regulated wallet, or somewhere in, let's say, a platform that originates in a non-regulated company that deals illegally from, let's say, Marshall Islands.
Or cold storage. When it's on a USB, you can't find it.
Exactly. So it depends on how the cryptocurrency exists in the blockchain. Yeah, it depends on the type of cryptocurrency, because for example, you may have very valuable cryptocurrencies, bitcoins, you have ethereums, but you have cryptocurrencies that nobody heard of. And probably this would exist in very dodgy environments where probably it's very difficult to find somebody and enforce. You know, a regulated exchange usually operates with KYC procedures. The identity is known. Obviously, there are all these AML and KYC processes that are done in the financial industry overall. So there is a possibility, but there are a lot of variables to be applied there.
If we want to squeeze in two more questions, quick response from Elias, and then we'll take two questions briefly.
Very quick response on that, just an additional thing to take note of is that even if the government or regulator or court identified that someone had a wallet before, they can't prove that they currently have it, because I could say that, oh, well, this actually happened with FTX. They had $500 million in the account, and then the day after they went bankrupt, the 500 million disappeared, and they said, oh, the wallet got hacked, someone stole it. And how do you prove? I mean, you could move it to another wallet, and then it's no longer there. They can't prove that you control the next wallet, and you can also say, oh yeah, I controlled that wallet, a year ago, I forgot the password. I buried my gold, I don't know where it is. You can't prove that you know.
Any other questions, please?
Obviously, for different metaverses to mature, disputes need to be handled well, right? And it seems to us that smart contracts need to be that much more intelligent. So are you seeing sort of how do you handle, I guess I'm asking, how do you handle the marriage between legal framework and the coding and the technology, and are you seeing a lot of talent in that space?
We need to be married. The future lawyers are going to be coders.
Yeah, that's true.
So since you're discussing about that, yeah, the future lawyers need to know coding.
Yeah.
That's, for me, this is a reality.
Yes.
And I think that the new hard skill that you would ask people in interviews is whether they know Solidity, C++, Java, etc. How to look into a smart contract, why to, let's say, put a certain provision there, so it's predictable that these institutions will be married. And this is actually the new generation of lawyers, because I think the legal profession overall tends to digitalize a lot. And then this is going to not to ensure an inflation hedge for lawyers. Lawyers would need to adapt. Because for as long as you have the code or the software or the AI who does most of your job, yeah, you as a lawyer would need to change your business pattern. You need to look into the back office of AI, of let's say VR, of Metaverse, because that's what's going to bring your value into the market. How you know to structure, to code, to make these machines work for you, and how to generate the rights and liabilities that you wish to generate. So I think marriage is there.
Last question before we finish, please.
I'm here because I have a software. Thank you very much for the insightful speeches. I will set a question as a lawyer for the arbitration issue, but as a mediator, because I'm very concerned after the speeches, I will also say something if I can.
Yeah, please, briefly.
Okay. As a lawyer, my question is, because actually we're talking of a new business, I agree with Dr. Laura, so we're going to have a new nature of disputes. We have a new terminology, we're not dealing with the jurisdiction as we know, we don't deal with public law as we know, everything will change. So for me, it was very important what Mr. Cohen said, that transparency must be married with the rules of evidence that future arbitrators will apply. I mean, what kind of rules of evidence can we have, let's say, if we're based on anonymity? How can the arbitrator investigate liability? So liability and evidence are something that I'm concerned with, how they're going to be diversified in the future in the metaverse. My question so will be to hear your insights, whoever wants to, your opinion on that. And as a mediator, I don't know if there are any colleagues mediators here, I'm quite concerned about the emotional part of the disputes. Now the mediators, arbitration, okay, because I also studied arbitration is a private justice, let's say, but the mediator is something different. non-lawyers as well. So when we deal with so, non-transparent, impersonal system, an automatic system, I'm really concerned about how will this emotional intelligence, empathy can be shown. Now we do digital mediation, and still there is a strong debate whether mediators can, understand the body language through a camera. If now I don't have a camera, I have 349-2. I mean, who is this 349? You see, the personal part of the dispute will disappear. So, just a question you have used if you want to deal with that, because it has to do with mediation, arbitrators are different. But still, it would be a huge and challenging different world.
The first question quickly. Who wants to take that?
I can attempt it.
Yeah.
So, no, you take the first one, I'll take the second.
Yeah, good.
Well, I actually like to take a step back for a second, because I think there's an overarching theme that connects all the questions that we've heard so far. If you look at human nature, we have things we like to do in private, and we have things we are openly sharing in public, or don't mind that it's shared in public. So if you look at the use case and the business model of each metaverse application or a cryptocurrency token, in that sense, that desire to either be public and private is driving the technology and its development. So if you look at certain crypto technology, it's completely private. No one is able to see what's going on. It's untraceable. So there will never be arbitration possible in that realm of the cryptocurrency sphere. Like you said, you cannot prove if someone owns a privacy coin and how much. So you could move your assets or your contracts to a space that is basically invisible for anyone. So that part of the realm of metaverse cryptocurrencies is completely private, and the technology is being developed to maintain it that way. I think that's why we have toilet doors. We like to have things hidden private. And then of course it's things, if I drink water, I don't mind if people see that. There's things that are okay to share publicly, and I think that part of the continuum, that's where arbitration is more required. And of course we see it already. If you look at the on-ramps, off-ramps, how do I acquire cryptocurrency? If you go to most exchanges nowadays, you cannot buy a cryptocurrency without showing your passport or your identity. So from there on you have, your customer, so at least you start understanding the beginning, who's the person behind a certain ID, like if you call it the 321 dash something. Of course, if you start moving that to wallets, it becomes a much more complex topic. But most of the cryptocurrencies, there is, they call it surveillance coins, so to speak. What that means is you can track everything on the blockchain. So it goes from A to B to C, and you can track all these links. The FBA, the CIA, they're all using chain analytics. So they understand what is going on. So in that sense, you can start tracking, building model. Of course, it's still complex and difficult, but you can see what is happening, where it's moving, etc. Having said that, that also gives you risk if you use these tokens that are surveillance tokens. Imagine I buy a Bitcoin. If that Bitcoin is not audited to be secure, it might be a Bitcoin that was used to fund terrorism. So the FBI might knock on my door saying, hey, you own this Bitcoin, where did you get it from? How are you so closely linked to a terrorist organization? Because a Bitcoin is used to fund that, even though you cannot see who owned it. You can see what it was used for, from which wallet it moved to, and they can of course link all these identities, so they have a vague idea. So I think that's where you have to see in which realm are you operating, in the public surveillance, open, transparent area, or are you more in the private sector? And that depends on the use case also, and that's why I see technology is building and developing in those use cases. And the technology is so far advanced that it stays invisible if you want to stay invisible. There's also, of course, public ones that are more used for government or for companies, because then you want to be transparent, you want to be traceable, because it also builds trust. So I think that's also where the arbitration should focus on, and also the mediating should be looking at that direction, because like I said, the other one is just impossible, it's invisible, and you don't want to look into that. It's like looking into a black box into the sky and you have no idea what's going on there.
So that's what we do for the human face of the technology.
Yeah, I mean, it's departing slightly. So it's departing slightly from blockchain with the human emotions, and because that's two very different things. But maybe in the future, arbitration, mediation won't happen in person in this kind of context. Maybe we'll have 3D goggles, and you'll have 3D goggles, and you'll wear a special suit that measures your body movements, and you can see the other person moving there, and it becomes this room, and it looks just like this, but we're in different countries, and maybe we'll have ways of conveying emotion online, just like we have emojis now to do that, but in a more advanced way.
All right, I think that's a lot of food for thought. We can carry on discussions, but with that, please thank Mr. Elias Ahun, Mr. Cohen Van Riel, and Dr. Laura Boda. Excellent, profound. Well done, guys.